Pretty sorry took a little bit longer than I anticipated. It ended up being a pretty good time to take a break. We had to take care of a few things out of your presence. So we were able to do that. We're going to continue on with the examination of this witness. Ms. Kite?
I may have Mr. Lardizabal step down from the stand again.
Yes, you may.
And if I may publish State's Exhibit 342.
Permission to move about, Governor.
Of course.
Where we left off, I'm going to ask you to look at State's Exhibit 342 and tell us if you recognize this exhibit.
Yes, I do. My markings are present on the container, along with the laboratory number 2016-040-0672. You can also recognize this particular item.
And if you could just show it to the jurors and tell them what your findings were on this particular exhibit.
Particular item.
This lot item, 98.
That is a 7.62 or 30 caliber class metal jacketed fragment. And I did examine it, and I found that it was fired from the rifle, the MAK rifle, that I'm examining this particular one.
So it was a conclusive match?
That is correct.
Now, if I may publish State's Exhibit 326, tell us if you recognize this and what your findings were.
Again, I do recognize this particular item by the laboratory number 2016-040-0672. My markings are present on the container as I placed them there. And this was a bullet that I examined in this particular case.
Okay, and what were your findings as it relates to this bullet?
That is a 30 caliber 7.62 class metal jacketed bullet. We did examine it and compare it to tests I fired with the rifle in question, and it was fired from that rifle.
So it was a conclusive match?
That is correct.
Showing you State's Exhibit 327. Tell us if you recognize this exhibit.
You do recognize it. Again, my markings are present on the container on the laboratory number 2016-040-0672.
And what were your conclusions as it relates to your analysis of this bullet?
That particular bullet is a 30 caliber 7.62 class metal jacketed bullet. It's been damaged, and although it does have rifling markings remaining on it, we could not conclusively determine whether that particular bullet was fired from the rifle in question. There are insufficient markings for conclusive results.
But it does still share the same cost characteristics.
Correct. The rifling style and even some of the markings are consistent with that particular firearm, but I cannot tell you that that bullet was exclusively fired from that firearm.
I'm going to ask that you look at this remaining bullet. It's lat item 57. Do you recognize that?
Yes, I do. I can do so again by the laboratory number appearing on the container and also on the item 2016-040. 0672. My markings are present on the container and also on other markings on the items.
And in this case, what were your findings as it relates to this particular bullet?
This is another jacket fragment. It is a .30 caliber 7.62 designation metal jacket. And I did compare it to tests that I fired with the rifle in question. And I determined that this particular jacket was fired from the rifle in question.
So this was a conclusive match.
That is correct.
Now turn your attention to State's Exhibit 350. Do you recognize that?
Yes, I do. And I can do so again by the markings present on the container and also the laboratory number, which is clearly visible on the container, the same number we've been referring to. And this is a 7.62 by 39 caliber cartridge case that has been fired.
And as it relates to this case, we've been talking, when we're talking about the Mac 90, we've only been talking about the bullet portion and not the casing.
Correct.
Is this a single casing that was submitted to the lab for comparison purposes?
This is a cartridge case that I examined in this particular matter for this particular caliber designation, 7.62 by 39 millimeters.
All right. And then what were your findings as it relates to this casing?
I determined that that particular cartridge case was fired with the rifle in question.
If you can take a stand again. All right, this time I don't have any further questions.
Cross?
Yes, sure.
Your Honor, my first witness.
You may.
First, good morning. Lardizabal.
Good morning.
You stated that State's Exhibit 350, the single cartridge case, 7.62 by 39, was fired from the Mac 90.
It was fired in that firearm, yes.
And how are you able to determine that?
By comparing then markings on the cartridge case to actual markings on the test-fired cartridge case that I produced in the laboratory. So microscopically, I examine the surfaces of the cartridge cases and look for markings then to see whether or not there was correspondence to suggest there was a common origin. And in fact, this particular examination revealed markings on multiple portions of the cartridge case that I could use to form my opinion.
The Mac 90, can you weigh it? How heavy is that Mac 90?
I did not determine the weight of that particular firearm, but typical MAK 90 weighs somewhere around 8-9 pounds or so.
In the Glock 26, what is the weight of that firearm?
I did not determine the weight of that particular firearm, but it's going to be perhaps 2 pounds or so.
Whenever a cartridge or a round is loaded into a magazine, first the initial cartridge is decompressed where the follower is that correct?
When installing the cartridge into the magazine, the internal components known as a follower and a spring are pressed down inside the body of the magazine. So the operator will individually install the cartridges into the magazine, and it will cause that spring to compress.
I noticed that when you were demonstrating it, you were using your thumb to decompress the cartridge. That's what is normally done, is that correct?
Typically, the operator can employ their thumb to do so. You can also employ other mechanical devices to assist you in loading firearms. There are even other devices that can enable, in the case of the MAC 90, very rapid installation of cartridges using what's known as a stripper clip.
You did not have any stripper clips submitted to you, is that right?
Not in this matter, no.
So whenever one is loading the magazine, they decompress the initial round, and then they put another round on top of that cartridge and decompress it, and it goes underneath the follower, is that correct?
Well, it doesn't go underneath the follower. It rather presses the follower sequentially down into the magazine. Each cartridge rests on top of each other when you have multiple cartridges in the magazine. So the follower is at the top when it's unloaded. As you press a cartridge into the magazine, the follower will move down into the body of the magazine as one installs more cartridges on top.
And that's why the magazine has a spring in order to have multiple cartridges or rounds loaded into it, is that correct?
Correct. It facilitates feeding of the cartridges up from the magazine into the action of the firearm.
You said you fired each of these weapons, is that right?
That is correct.
How many times did you fire each of the weapons?
The MAK I fired twice. And I also fired the Glock twice.
Okay. Whenever you fired the Glock, did you have the Glock in the vertical position?
The Glock was fired in a slightly downward angle. The test firing container that I employ in a laboratory to recover fired bullets is a water tank, and it's got a firing port at one end of it, and the operator has to slightly incline the firearm in a downward position. It's not straight down, but it is held a little bit in the downward position.
When the weapon is fired in a vertical position, the cartridge case is ejected up and to the right and back, is that correct?
When you say vertical, are you referring to pointing the barrel of the firearm vertically?
I'm talking about the holding of the weapon in a standard way.
A normal orientation
Yes,
of firing.
Normal range fire.
With the barrel held horizontally, and if the operator looking straight forward, if you think of that as a 12 o'clock position, and immediately behind the operator of the firearm is a 6 o'clock position, this particular Glock firearm is designed to normally extract and eject the cartridge cases off to the 3 o'clock direction in general. They can vary from straight forward to straight behind you, but typically with the extractor located then on the right side of the firearm, they'll go off to the right-hand side of the operator. That's a normal operation.
Normal operation as if at a range, is that right?
Well, again, if you're firing the firearm in a horizontal position, that's typically where the cartridge cases will go, is off to the right. Many different factors affect whether or not the cartridge case goes straight up in the air, straight forward, behind the operator. They can even roll in the ground, so they may be found off to the left of the operator. So I did not determine an ejection pattern for this particular firearm. I did not conduct that type of study.
If you're holding the firearm flat, like I've had in my hand, where would the cartridge case be ejected to?
If you were to have the gun in a normal operating condition, that is my hand holding the firearm in this orientation with the muzzle facing away from us, typically, again, they'll go off to the right-hand side of the operator. If one were to cant the firearm, that is, roll it over to the side, either this way or this way, the cartridge case will go in a different orientation. It may go straight up, it may go slightly forward, it may go behind the operator, they could even go off to the left side or the right side. Very subtle changes in not only the orientation of firearm, but even more importantly, the amount of force that is applied to the firearm as you hold it. Those all can greatly affect where the cartridge case ultimately goes.
When you were firing the MAC-90, how did you hold that weapon?
With two hands.
Okay. Could you show the jury how you held it?
I had my left hand supporting the forward portion of the firearm and the right hand on the pistol grip.
And you were sighting down the weapon, is that correct, with your eye?
No, it was actually oriented into the tube of the firing port of the tank, and I was inspecting the angle at which it entered the tube and also its linear orientation, so I did not employ the sights of the firearm in order to produce my test.
But the firearm does have a sight on the end of it for that purpose, does it not?
It has a front and a rear sight.
Okay. And that's to look down those sights for a target, is that right?
Sights are provided on firearms to try and align the arm with your given target.
And that MAC-90 ejected the cartridge case up and to the right also, is that right?
Typically, that particular firearm extracts and ejects cartridge cases rather vigorously to the 2 o'clock position relative to the operator. And again, if we're facing firing in this general direction, as I've indicated with my arm and hand, and that would be the 12 o'clock position. The 2 o'clock position is typically where that type of firearm extracts and ejects cartridge cases. Now, it can do that also depending on how you're holding it, and even more importantly, with the particular ammunition you're using, it may eject them to slightly differing positions. They can vary even almost all the way behind you, but it is a vigorously operating system.
Your Honor, I have no further questions.
Cross.
All right.
Good morning.
Now, you indicated that you test fired the long gun, is that correct?
I personally test fired both firearms in this matter.
Okay. Can you tell me how you held the long gun?
As I indicated earlier, I had my left hand supporting the firearm. It's relatively heavy, and then my right hand was on the pistol grip portion of the firearm, placing it into the test firing tank, pressing the trigger. After it recoiled, I fired it again.
Okay. Can you show us with the firearm that we have in evidence exactly how you held that firearm?
Certainly.
Would you be able to do it, is my question.
Oh, I certainly could if you wanted me to demonstrate that.
You may.
This is Lardizabal. I'm going to show you what's been marked with evidence.
It's 298.
298. Can you take this out and show us how you would hold that to fire that firearm?
All right. As I test fired this firearm at the laboratory, I employed the magazine that was supplied with it, loaded 2 cartridges into the top of the magazine, pressing them into the upper portion. Then installed the magazine into the firearm, and then using the operating handle on the bolt carrier, I retracted it to the rear and let it go forward. And then I placed it, if we're envisioning this is a test firing tank, there's a stainless steel tube, a port. I held it in this orientation into the port, pressed the trigger, the gun recoils, self-loads, I release the trigger, and then pressed for the second shot.
Now, is there any other way to handle that firearm?
I'm not sure I understand your question.
Would you be able to hold it, well, hold it for a second,
Certainly.
with 2 hands like this? I'll show you.
That's called flagging, Miss Wright.
Can you hold it like this and fire it?
Well, if your hands are surrounding the trigger guard, you're not going to necessarily be able to press the trigger. You can employ one hand to fire this particular firearm, although it is heavy, and you can employ 2 hands to fire the firearm. And for myself, that would be relatively easy to do.
Right.
So it can be done with one hand in this configuration.
But if you were holding it with 2 hands like you were just now, you could fire it that way.
Certainly.
But then whatever the clip, the nano clip, as they call it, would be in front of it, is that correct?
The magazine would be in front, yes.
Okay, and so that would be clearly visible if I'm looking at you firing it head on, is that correct? The magazine, you would see the magazine before you see your hands, would that be correct?
Again, I'm not sure I understand the question.
If you're firing that firearm, and I'm looking at you firing the firearm, would it be, can you see the fingers, your hands around the gun without seeing the clip?
Where would you be relative to my position when I'm firing?
Just either in front of you or to the side of you?
Well, if you're in front, you're going to be potentially shot by the firearm, in which case it would be difficult to see the magazine because you're going to be aligned with the whole firearm.
Right.
If you're off to the side of the firearm, it's a rather prominent feature of this particular arm at this moment. So potentially it would be relatively easy to spot it if the visual conditions were such that you could see it. If it's dark, it might be very difficult to see given the dark nature of the arm.
Right.
If it's full daylight and you didn't have a contrasting dark background, I would assume it'd be pretty easy to pick it up.
But if you couldn't see the arm, you probably couldn't see your hands on the back of the holding whatever that is in place of the...
And I can't necessarily speak to whether or not an individual would be able to see my hands or not on a particular firearm. Again, it would be relative to their position and time of day, other circumstances. Certainly in a firefight situation, it's very difficult to detect things, but that would certainly be an individual matter for the witnesses at hand, whether or not they could or couldn't see it. I can't speak for them individually.
Okay, thank you. Now, Mr. Lardizabal, you are pretty familiar with firearms, is that correct?
I have a lot of experience with them, yes.
All right, and you'd be able to recognize a firearm by sight if you saw it, is that correct? Generally speaking.
The visual silhouette of firearms can be relatively easy, sometimes challenging to recognize, if you will, identify. And there are many different firearms out there that have been replicated in plastic and various other forms and are not in fact firearms. And so a photographic or video presentation of what's depicted as an arm may or may not be a firearm in any given case.
All right. Now, if I were to show you some some photographs, could you look at them and determine whether or not you could ascertain the type of firearm it is?
Well, again, I can look at photographs and tell you if it's consistent with something in particular, but I'm not going to be able to make a determination if it's a firearm without actually examining it.
Your Honor, may I approach the witness?
You may.
Mr. Lardizabal, I'm going to show you this photograph that's in evidence as Exhibit 507. There are three guns in this photograph. Can you look at those and tell me what they are?
All right, the individual arms depicted in this image are consistent with a couple firearms that I'm familiar with, but again, I cannot determine whether or not these objects held in these individuals' hands are actual firearms or not. Okay, but they're consistent in appearance with a particular series of firearms that I would be familiar with. On the left-hand side, there's a handgun being pointed in the general direction of the camera, and the front portion of it is consistent with a Glock type slide assembly on a firearm. The middle one appears to be more of a Springfield Armory XD type, but again, without examining the actual item itself, I can't make a determination of what type of firearm that is, or if it's in fact a firearm. And then the last individual holding the arm on the right-hand side of this image, a portion of the long arm is being held in a downward orientation. That's consistent again with an AK type. Now, AK refers to a semi-automatic firearm and actually fully automatic firearm that employs a receiver and operating system of general configuration, the type that we have in this rifle that I examined in this particular case. They can have shorter barrels, longer barrels, different types of stocks on the front and the back, and this particular image depicts something consistent with that type of firearm.
Okay, what about the individual in the middle with the one with the green beam? Are you able to see any part of that to determine what type of fire, well, the green beam?
That would be
Beam.
this one?
Yes.
Yes.
But the other hand.
Right. Again, that appears to be a Springfield Armory type firearm, an XD type semi-automatic pistol. But again, the resolution of the photographs are not very good, so I can't be specific as to the model type, if you will, or even if it is actually a firearm.
Right.
Again, there are many things that have been made to look like firearms, and in fact, they're replicas. So without actually examining these particular items, I can't tell you whether they're firearms or not.
What about the item in the guy in the middle in his left hand? Could you determine what that is? Yes.
There appears to be a green light source, and there's a linear projection from it. Potentially, this could be some type of green laser.
Okay, but you can't determine what type of firearm, if any, is in the individual's left hand, is that correct?
There's an object projecting down below it, but I can't even see whether or not it's an apparent firearm or not.
Okay, thank you. Mr. Lardizabal, you also talked about accessories that go on firearms.
We did discuss briefly some accessories that could be fitted to firearms, yes.
Now, are you familiar with beams that can be fitted to firearms?
There are many different light sources that can be installed on firearms to facilitate operators' vision or potentially align the firearm with intended target.
Now, with regard to the Glock 26 that's in evidence, does it have an accessory rail for the attachment of those type of objects?
That particular model Glock does not have on its frame as you noted, an accessory rail for easy installation and removal of accessories.
I don't have any further questions.
Redirect.
Does it need it? Does it need a rail to put certain beams on it?
As we noted earlier, no. They can be attached to the grip portion or even to the trigger guard assembly.
All right, may this witness be excused?
Yes, Your Honor.
All right, thank you. You are excused, sir.
Thank you.
State.
Your Honor, the state rests.
All right, ladies and gentlemen of the juries, the state has now rested its case which means we need to take care of a few things outside of your presence before we can continue on with the trial. We're still on track with what I had mentioned on Friday with Mr. Hayes, your jury, y'all getting the case sometime this afternoon, and Mr. Richardson's jury coming back tomorrow morning. But there's still some more things that we need you to do even before we break for lunch. So I'm going to have you kindly follow Ms. Crawford and Ms. Graham out to the jury rooms. We'll see you in just a few minutes, okay? We're going to call Ms. Ashley Clark as a witness. Are there any other witnesses that you plan on calling?
There are no other witnesses that I plan on calling.
All right. Then I'm going to talk to Mr. Hayes. If you could please stand, sir, and to be sworn.
You solemnly swear affirm that the testimony will be the truth, the whole truth, nothing but the truth, so help you God.
All right, Mr. Hayes, the court has now received all the evidence in the case, the state's case in chief against you. Do you understand that it is the state's burden to prove the charges against you beyond a reasonable doubt? Yes, sir. And do you understand that you do not have to prove or disprove anything in this trial? As such, you do not have to testify. You have the absolute right to remain silent in this case. Do you understand that? Of course, you also have the absolute right to testify if you choose to do so. Do you understand that as well? Now, the decision to testify or to not testify is yours and yours alone to make. You have a very experienced lawyer, and you should certainly consider his advice about whether you should or should not testify. But in the end, only you can make that decision. Do you understand? If you choose not to testify, I will instruct the jury that in every criminal proceeding, a defendant has the absolute right to remain silent and that they are not permitted to draw any inference of guilt from your exercising of your right to remain silent. Additionally, I will tell them that the fact that you did not take the witness stand must not influence their verdict in any manner whatsoever. Do you understand that as well? And if you do choose to testify, you'll be treated like any other witness. You'll be placed on the placed under oath and to take the witness stand to be first examined by your lawyer and cross-examined by the state. If you have any convictions for felonies or crimes involving dishonesty, the state will be able to impeach you. Does he have any such convictions? Right. That's what I thought. So you don't have any prior convictions. Now, have you had enough time to speak with Mr. Hernandez about whether or not you wish to testify?
Yes, sir.
Has he answered all of your questions about that decision?
Yes, sir.
Do you need any more time to consider this question?
No, sir.
All right. And have you made a decision?
Yes, sir.
What is your decision?
I said not to.
You're not going to testify?
Yes, sir.
Has anybody threatened you or coerced you to get you to make that decision?
No, sir.
Has anybody promised you anything in order to get you to make that decision? So decision not to testify, you're making that freely and voluntarily on your own?
Yes, sir.
Okay. Now, you understand I just asked Mr. Hernandez if he has any witnesses. He's going to, or Ms. Wright is, but Mr. Hernandez is going to be able to question her as well, Ms. Ashley Clark. And then I'm going to advise the jury that sunset took place on the day in question at 6 p.m. and darkness descended in Jacksonville at 7:23 p.m. But other than that, the defense doesn't have any witnesses or exhibits it's going to offer. Do you understand? Are there any witnesses that you wanted Mr. Hernandez to call that he's not going to? Are there any exhibits or documents that you want him to offer to this jury to consider that he's not going to do? All right. Are you satisfied then with Mr. Hernandez's work in your case? All right. Very well. Then you can take your seat. Thank you, Mr. Hayes. Ms. Wright, I understand obviously you're going to call Ms. Clark to the stand. Are there any other witnesses that you plan on calling? Or exhibits or documents that you are going to offer?
Just one, actually.
Let's get Ms. Clark ready. She's on her ready. Okay.
Actually part of the phone record of the same contract, but I'm not sure what, because I didn't get a chance to look at this, exactly what the state put into evidence in regard to Mr. Bradford, this. But I do need to make sure that the cover letter portion of his phone records goes into evidence, because it tells how to read the cell citation. It indicates that it's not reliable. I don't know if the state, maybe I could have been my record, I never just see that this.
Okay, well, let me ask, Ms. Kite, do you know of what she's referencing?
I'm not sure. We provided a complete set of the records that we provided to us.
But if for some reason this cover letter did not get in, do we have an objection to it coming in?
No, sir. It's a statement on the record that indicates that it's not intended for a location, but it is used for those purposes. So I don't have any problem putting that in.
Okay.
I think that's what she's referring to.
If it's not already in, it may already be in. We'll just need to confirm that. All right, Mr. Richardson, then if you could please stand to be sworn.
Do you solemnly swear affirm that the testimony you will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, Mr. Richardson, this court has now heard all the evidence in this state's case in chief against you. Do you understand that? Do you understand that it's the state's burden to prove these charges against you beyond a reasonable doubt? As such, you do not have to prove or disprove anything in this case. Do you understand? As such, you do not have to testify in this case. You have the absolute right to remain silent. Do you understand? Of course, you also have the absolute right to testify in this case if you choose to do so. Do you understand that as well? Now, you also have a very experienced lawyer in Ms. Wright, and you should certainly consider her advice in making the decision about whether you should testify or not. But in the end, that decision is still yours. Do you understand? If you choose to testify, if you choose not to testify, I will instruct the jury that in every criminal proceeding, a defendant has the absolute right to remain silent and that they are not permitted to draw any inference of guilt from your exercising of your right to remain silent. Additionally, I will tell them that the fact that you did not take the witness stand must not influence their verdict in any manner whatsoever. Do you understand? And if you choose to testify, you'll be treated like any other witness. You'll be called to the witness stand, placed under oath, first examined by your lawyer and cross-examined by the state. Do you understand all that? Now, does he have any felony convictions? Okay, correct. All right, so you won't be able to be impeached either, like some witnesses have been with their prior felony convictions. Now, have you had enough time to speak with Ms. Wright about your decision about whether or not you're going to testify? Okay, so you have not made a decision? Okay. So if I give you a few more minutes, you'll be able to make that decision? Okay, go ahead. I'll give you a few minutes to discuss it with Ms. Wright. He wants to talk to you some more about whether or not you should testify. Well, yeah, that's what we're doing. All right, I gave you, it probably wasn't even a minute, but you were able to talk some more with Ms. Wright just now? Well, I understand. An agreement's probably not necessarily the worst word to use, but you understand it's still your decision, not sort of a joint decision. Okay. And you've had enough time to make that decision. Has anybody threatened you or coerced you to make that decision? Has anybody promised you a certain thing in order to get you to make that decision? And so that decision to not testify is yours, that you freely and voluntarily made? Okay. Now, you've heard me also ask your lawyer that she is going to call Ms. Clark as a witness, and that's the only witness she has. Do you understand that? Are there any witnesses that you wanted her to call that she's not going to call? Are there any documents, exhibits, photographs, etc., that you wanted her to show this jury that she's not going to show? All right, so you're satisfied then with her representation in this case? Okay. All right, you can have a seat, Mr. Richardson. Okay, Ms. Clark is in the chute and she's ready to go. I propose in just a moment we bring her out, after we bring out the juries, of course. And Ms. Wright, I'll allow you to call her, and then we'll go through the questioning. And then at the end of that, I'll read the statement regarding sunset and darkness. And then at that point, I guess the defense would rest. I will send Mr. Richardson's jury home. We'll send the other jury to their lunch break. We'll make the final tweaks to the jury instructions. We'll come back earlier from lunch than the jury. We'll have our charge conference, and then we'll go into closing arguments in Mr. Hayes' case. Everybody agree to that schedule? All right, as to Ms. Clark. Yes, sir.
Just whatever's my time, if you close the argument, I'll be about 10 minutes and around 8 minutes.
I'm going to give you the time that you need.
Yes, sir.
Don't worry. All right, as to Ms. Clark, we had some extensive off-the-record conversations during our morning recess. So I want to make sure that's off record before we bring her in. So Ms. Kite, state for me, or for the record, concisely your issue with being able to cross-examine Ms. Clark.
My understanding of what Ms. Clark was going to be able to testify to today is that she had a conversation with Saquon Bradford shortly after her child was shot on Christmas Day, which is part of the evidence in this case. And during that conversation, he said some words to the effect of that did she want him to take care of it? And then that is my understanding of what she's going to say. So it's being offered by the defense as a statement against interest. I know that subsequent to the statement that the defense is going to put forward, Ms. Clark got arrested with Henry Hayes in this case. She was interviewed by the detective, and subsequently I took a sworn statement of her on March 2nd. During that sworn statement, she indicated the statement that is subject to what they were trying to introduce. 4 days later, Ms. Clark got out of jail. She went immediately to go have a visitation with St. Paul and Bradford so that the detectives can continue their investigation as to whether he was responsible in the death of Aiden. Instead of stating that he took care of it, he instead said that it was these two defendants along with two others that were involved. At sidebar, I requested the court allow me to get into the statement because initially when she communicated that during the sworn statement, she indicated that she didn't really believe Rondo and that he was just trying to impress her. And then later on when we tried to get the statement on recording, he actually said the exact opposite of what she indicated. So therefore, I am submitting it the two statements is inconsistent with one another for the jury's consideration on the first issue of whether the first statement was in fact believable.
All right. The two statements being, do you want me to take care of this for you? And the second statement being, the subsequent jail conversation, Hayes and Richardson and others are responsible.
Yes, because I think that the inference that the defense is trying to draw from the first statement is he's the one that in fact did it.
Right.
So then, I think that's a reasonable inference based upon the statement in and of itself. However, there was a subsequent statement where she tried to get him recorded, and it was an opposite statement of the first one. So I would say that draws into question the credibility of the first statement that she claims to have given.
All right. And obviously, Ms. Wright, you don't want me to allow the state to elicit this subsequent statement by Mr. Bradford that it was Mr. Hayes and Mr. Richardson and not him who did it, correct?
That's correct.
All right. Let me state what I think is the issue here. One, the statement, do you want me to take care of this for you, on December the 25th, 2015, a month and 4 days prior to the issue, is this court's opinion, fairly limited weight. It's for the jury. I'm not saying it's not admissible. I just don't know that it carries a whole lot of weight. I understand why the defense wants to use it, and they're going to be able to use it. The witness who's going to be called next is Ashley Clark. She may be impeached for issues of bias against the state, her felony convictions, any crimes of dishonesty. She may be impeached because she has bias in favor of the defendants. This is basic stuff. 608 of the evidence code says that prior inconsistent statements are not hearsay, but only prior statements of the witness who is testifying and having his or her credibility attacked are admissible for this purpose, which is the concern I brought up earlier during our sidebar. You're impeaching Bradford by showing his prior inconsistent statement, and he's not the witness. So I'm not going to allow the statement that he made to her on the jail that it was these two defendants who did it come in as a prior inconsistent statement because he's not testifying. Which doesn't necessarily mean you can't call him in rebuttal to say, I didn't make that statement, or I did make the statement, here's what I meant by it. I was trying to woo her. And just because I said I was going to take care of it doesn't mean I'm going to go shoot up the neighborhood a month and a half later. I mean, all those things are fair game. Whether or not you can later, if you call him in rebuttal, and that's up to y'all, get in the statement at the jail as a prior consistent statement. I've indicated I'm not so sure about that. I'll think about that over our lunch break, because I think we're going to have to take a lunch break before we do any rebuttal anyway. So that's my ruling. Quickly. Sure.
After December 25th, after the death of Aiden Defendant, Mr. Bradford told the witness that he took care of that. So I just
Well, I didn't know. If that's been said, then I missed this, that. I know he said, will take, do you want me to take care of that on December 25th? Is there a statement that he says, I already took care of it after he was killed? Aiden was killed?
She said accept.
When did she say that?
She doesn't give a date.
Well, again, then that's, I think, fair game for cross-examination, state. But to offer his jail statement as a prior inconsistent statement, I don't think you can do that because it's got to be the witness on the stand. That's what the rule says. Okay? All right, any reason we can't bring in these juries and bring in this witness? Bring in the juries. As you heard, the state has rested their case, which means we're going to move on to the next stage of the case. Ms. Wright, would you like to call a witness?
Yes, Your Honor, we call Ashley Clark.
All right, Ms. Ashley Clark.
Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, Ms. Wright, you may inquire.
Thank you, Your Honor. Ma'am, can you tell us your full name?
Ashley Clark.
And Ms. Clark, do you know an individual by the name of Kwame Richardson?
No, ma'am, I know of him.
Have you ever met him before?
No, ma'am.
Do you know an individual by the name of Sanquan Bradford?
Yes, ma'am.
Can you tell us how long you've known that individual?
Now probably about 3 years.
About 3 years? Okay.
Yes, ma'am.
Can you tell us how you met him?
I met him through a guy named D. Rose, Breon.
Okay, so you met him through Breon Mason?
Yes, ma'am.
Okay. Were you in a romantic relationship with him when you first met him?
No, ma'am.
Were you dating Breon Mason?
Ma'am?
Were you dating Breon Mason at that time?
Yes, ma'am.
Okay. I want to take you to Christmas 2015. Were you present at an incident?
Yes, ma'am.
Can you tell us what that incident was?
We were at a candlelight visual for one of Breon's friends, and we hadn't got out the car yet, and somebody did a drive-by, and my daughter got shot.
Okay. I'm sorry, who did you say was shot?
My daughter.
Okay. Now, did you know the individuals who did that drive-by? Could you tell who they were?
No, ma'am.
Your daughter was injured that day, is that correct?
Yes, ma'am.
So, did you take her to the hospital?
Yes, ma'am.
Now, did you subsequently speak with detectives about what had happened at that shooting?
Yes, ma'am.
And during the course of that conversation, did you gain knowledge that the person who may have been responsible for shooting your daughter was Reginald Williams?
Say the last part again.
The person who may have been responsible for shooting your daughter was Reginald Williams.
Yes, ma'am.
And that's the individual that they call Ducci.
Yes, ma'am.
Did you know Ducci prior to December 25th?
No, ma'am.
Had you ever met him before?
No, ma'am.
Had you ever hung around him?
No, ma'am.
Now, after that shooting, did you remain in a relationship with Breon Mason?
For a little while.
Okay, for how long? Tell us, was it days, weeks?
It was during the remaining stay while my daughter was in the hospital, so not even a month probably at the most.
Now, while your daughter was in the hospital, did Sanquan Bradford come to visit her?
Yes, ma'am.
On how many occasions?
Probably about 3 times.
Did you ever discuss with him who was responsible for the shooting of your daughter?
Yeah, he told me, he was one of the people that told me that Ducci did it.
And what was your response?
I heard it was an accident.
Okay. Now, when you and he talked about whether or not Ducci committed this offense, did he say anything to you about it?
After my daughter had got out the hospital, we were at my house one day, and I was upset. I was going through like a really rough depression stage, and he was asking me what I wanted him to do about it.
Okay. And what did you take that to mean?
Did I want some type of revenge, I guess?
Okay. Do you recall specifically what he said to you?
Yes, ma'am. He asked me if I wanted him to kill Ducci's baby or somebody in Ducci's family.
And your response was?
I told him that I was just grateful that my baby was still alive.
Did you have any further discussion with him regarding your daughter prior to the death of Ada McClendon?
No, ma'am.
Now, did you enter into a relationship with Mr. Bradford?
Yes, ma'am.
When was that?
After me and Breon had stopped talking, we had some drama going on with, I guess, his prior girlfriend, and a fight occurred and all that. And Breon was involved in it, so me and him stopped talking. And I guess somewhere along the line, Breon and Sanquan stopped being friends, so it was kind of like a get-back thing, I guess, for both of us.
Okay.
And we started seeing each other.
Can you give us a date or a time frame as to when you specifically started dating Mr. Bradford?
It had to be in January.
So at the time of the, prior to the death of Ada McClendon, how long would you say you were in a relationship with Mr. Bradford?
With who?
Mr. Bradford, Sanquan Bradford.
I knew him for a while, but we didn't start really dating until probably around the time it happened to my daughter, a little after.
All right. Now, do you recall when the news was out that Ada McClendon had been shot?
Yes, ma'am.
Did you have a conversation with Sanquan Bradford regarding that?
Yes, ma'am.
Can you tell us what that conversation was?
I asked him if he had heard about the baby getting killed around the same area that Bailey had got shot, which is my daughter. And he said that he told me he was going to handle that for me. And he said it was something about karma.
Okay. So he told you, I told you I would handle that for you.
Yes, ma'am.
What did you take that to mean?
I guess maybe he had something to do with what happened to the baby.
And when he told you that, was he upset?
No.
What was his reaction?
Looked like he showed no remorse. Like he just had a blank stare. He was smiling a little bit.
Now, after that, did you go and call the police?
No, ma'am.
Why not?
I didn't really want to get involved with it. I didn't know if he was serious or if he was trying to get some brownie points with me or what, or if he thought I was going to be happy. So I wasn't sure.
Now, when he told you that, around that time frame when he told you that, can you tell us, was he coming to your house more often?
Yes, ma'am. Once he found out where I stayed, he would, because I had stopped answering the phone for him. I kind of fell back from him because he was kind of crazy. So
Sustained.
Okay, can you tell us about how he was staying at your house?
Once he found out where I stayed at, he would always get dropped off or come unannounced without me telling him to.
And did he tell you he was hot?
Yes, ma'am. He said that he thought he had a warrant. He didn't say what for, but he just said he thought he had a warrant and he couldn't be at his mama's house.
So he refused to go to his mom's house?
Yes, ma'am.
I don't have any further questions.
Mr. Hernandez.
Good afternoon, ma'am.
Good afternoon.
Ma'am, do you know my client Henry Hayes?
Yes, sir.
How long have you known him?
For a few years, about 3 years.
Okay. Have you ever dated my client?
We had a good friendship. We weren't really dating. I didn't know him that long before he got arrested.
After he got arrested, have you put a tattoo on yourself that says my client's name?
Yes, sir.
Okay. Why did you do that?
Just because I liked him.
Okay. And when did you do that?
I don't know the exact date.
Pardon me?
I don't know the exact date time I got it.
Was it about 3 years ago?
Yeah.
Okay. I have no other questions, Your Honor.
Cross.
Ms. Clark, tell everyone how old you are.
31.
And back in 2016, how old were you?
29.
All right. You indicated that back on December 25th, 2016, you were dating Breon Mason, who goes by the nickname of D. Rose. Is that correct?
Yes, ma'am.
And at the time that you called yourself dating D. Rose, he in fact had a girlfriend. Isn't that true? He in fact had a girlfriend by the name of Shatanya, correct?
Correct.
And you referenced that during the direct examination of Ms. Wright, right? You said that you broke up with him shortly after the shooting because there was a fight between you and his girlfriend, correct?
Yes, ma'am.
All right. And at the same time that you were dating D. Rose, you had another boyfriend. Is that true?
Yes. Just like he had a girlfriend, I had a boyfriend. It wasn't like official.
All right. But you were dating someone else, correct?
Yes, ma'am.
And then at the same time, you said that you pull up to this party on December 25th, 2016. You didn't know D. Rose is a deceased friend, did you?
No, ma'am.
Okay. You pretty much just met him, right?
Just met who?
D. Rose.
No, I had been knowing him too.
All right. And then while you're there, there's another person there, his brother, Keon Mason, correct?
Correct.
And you said that, oh yeah, you talked to the detectives, but isn't it true that you told the detectives that you don't know who shot your Bailey, do you?
Correct. I didn't. There was rumors going around. I never said for sure who it was because there were several people shooting back.
All right. Because at the time of the shooting of Bailey, you were actually looking down. You didn't see it, correct?
Correct.
And in fact, some of the rumors were that Keon Mason, who had a gun that day, is responsible for the shooting of your baby, right?
Yes, ma'am.
That's who you thought it was. Right?
I thought that because how hysterical he was, and I heard him say something about him firing a gun, but it wasn't the same kind of gun that shot Bailey.
Exactly. But that's what you thought, right?
Yeah, that was the first thing I thought.
And then, so let's fast forward in time. You say Rondo comes to visit your child in the hospital a few times, correct?
Yes, ma'am.
And then after he visits, he comes and y'all have some pillow talk, right? Because at this point in time, you were sleeping with Saquon Bradford, correct?
Yes, ma'am.
And he's how old, 17, 18?
He was 18.
He was 18?
Yes, ma'am.
You're 29?
Mm-hmm.
All right. And so you're having pillow talk with him, and the subject comes up about him getting even with the person who he heard shot Bailey?
Yes, ma'am.
You would agree with me that Saquon Bradford wasn't anywhere around that shooting that is on December 25th, 2015, I should say, right?
Not that I know of.
Well, he didn't say he was there?
No. There were several people there. It was like a party, so I don't know all who was there. I never got out the car.
And you didn't take him seriously, did you?
Not really.
All right. And then, so you start dating him. You think he's like a bugaboo because he keeps coming around when you don't really necessarily want him, right?
Correct.
He says he's hot, but he doesn't say why.
Correct.
You don't know if it's a carjacking or what it is, right?
I didn't know. He never said.
Okay. And then you're saying this time in which you are kind of, when you agreed that you were thinking he was a bugaboo and you're not kind of keeping him at arm's distance, he came to you and said something about the shooting of A.D. McClendon, right?
Yes, ma'am.
Okay. At this point in your mind, had you moved on from him?
I mean, he was one of them type of people that he almost didn't let me move on. Like, he would just push himself on me.
All right? And I'm talking about you. In your mind, had you already moved on from him?
I mean, I never really liked him in the first place. He was all right, but he liked me more than I liked him.
All right? Did you think what he was saying about Aiden, did you discount it because you thought he was trying to impress you?
I kind of thought he was trying to impress me.
Did it win you back?
No.
So you moved on, right?
Yeah.
Tell him the next person you ended up dating out of this crew.
Overruled.
Who did you move on after St. Juan Bradford?
I wasn't dating anyone.
Okay. But at some point in time, after this, you started dating Henry Hayes, right?
Not dating him, but we were friends.
All right. You liked him a lot, right?
We were all right. I really didn't know him to say I liked him a lot, but
You knew enough to get his name tattooed on your body, right?
we got closer after he was incarcerated. But when I first met him, it wasn't, we were just friends.
All right. And you would say the time and frame that you liked him, he was 16 years old, ma'am?
Yeah, but he told me he was 18.
I know, but he was 16.
Okay, I didn't know that though.
Overruled.
So in your mind, the responsibility of the shooting of Bailey, you think is a complete and total accident, true?
Yes, ma'am.
So you would have never put anybody up to get revenge for you, right?
Correct.
You would have never incited anybody about that, correct?
Correct.
Because you said you determined from Detective Howard that it was friendly fire, that is firing back at the people that were shooting at them, correct?
Correct.
The relationship that is with San Juan Bradford, you termed it to be get back at D. Rose, right?
Yes, ma'am.
The fact that you were sleeping with San Juan and he was sleeping with you, you were trying to hurt Breon Mason that way, correct?
I guess you can say that.
As you sit here, ma'am, isn't it true that you've been prosecuted by the office that I represent multiple times? True?
Yes, ma'am.
Okay. And you are a 10-time convicted felon?
Yes. No violent charges, mostly license.
Okay, but you've been convicted of felony 10 times, right?
Yes, ma'am.
Grounds. No, just state your ground. Well, then, we need to get that correct. How many times has she been convicted felon? Go find out.
Well, she agreed to the number. I asked her if there were 10. And you
I don't know how many times I've been convicted, but I know it was just license charges, so nothing serious. I don't know the exact
All
number.
right. Just,
if I may approach with
you
the
may.
record.
You may. All right, folks, come to sidebar, Madam Clerk, please join us. Ms. Kite, you may continue.
Ma'am, you indicated that San Juan Bradford said to you that asked you if you wanted him to kill Ducci's baby. Is that correct?
Yes, ma'am.
Ducci didn't have a baby back in December 25th, 2015, did he?
I don't know what he had. I just know that's what he said. That's what San Juan said.
All right, you figure out who Ducci is since that date, correct?
Yeah.
And he did not have a baby back.
Overruled.
I don't know what he had, ma'am.
You couldn't do the math and knowing that his baby was born.
I don't know anything about his baby or how many kids he has.
All right, move on, Ms. Kane.
All right. Outside the 10 felony convictions you have, you also have
Grounds? Adam?
I didn't hear you.
That's right. Just ask the question, Ms. Kane.
Outside the 10 felony convictions that you have, you also have 2 crimes of dishonesty, true?
What's that? Dishonesty? What do you mean?
Stealing? You
I have-
convicted of that 2 times?
No, I have one petty theft charge.
So 1 crime.
A misdemeanor petty theft.
Nothing further.
Redirect?
Yes, Your Honor. Ms. Clark, you indicated that you got that tattoo 3 years ago. Can you give us a reference? Was this after Henry, was this after this incident?
It was while he was incarcerated.
Okay. So in March of 2016, did you give a sworn statement regarding this incident?
Yes, ma'am.
And is that when you told the police that Sanquon Bradford had told you that he took care of it?
Yes, ma'am.
And that was prior to your getting that tattoo, is that correct?
Yes, ma'am.
I don't have any further questions.
All right, may this witness be excused? Oh, Mr. Hernandez, did you have any questions?
No further regret.
All right, may this witness be excused?
Yes, Your Honor.
All right, she's excused. All right, Ms. Wright, any other witnesses?
No, Your Honor.
Mr. Hernandez?
Your Honor, since we had adopted Ms. Clark also, at this time, Your Honor, I would ask the court to take judicial notice of the old Farmer's Almanac as far as the sunset and the time sharpness on January 29th, 2016.
All right, ladies and gentlemen, the court is pursuant to Florida statutes and the Old Farmer's Almanac, takes judicial notice of the following. 1, that sunset took place on January 29th, 2016 in Jacksonville, Florida at 6 p.m. 2, darkness descended on January 29th, 2016 in Jacksonville, Florida at 7:23 p.m. All right, Mr. Hernandez.
Nothing further, Your Honor.
Defense?
Defensive risk.
Ms. Wright?
There is one other document that I mentioned previously that I also this is the defensive one.
Is that the aforementioned cover letter?
Yes, Your Honor.
All right, any objection? State?
No, Your Honor.
All right, that will be entered as Defense Exhibit 1.
Thank you, Your Honor.
All right, anything else from Mr. Richardson's defense? Defense rest? All right, folks, the defense has rested their cases, which means, again, we have to take care of a few things out of your presence. And I also need to talk to the lawyers about scheduling, about when I could continue on with the trial and let Mr. Richardson's jury go home. So if y'all could just kindly wait back in your jury rooms, I'll bring it back out here fairly soon, and we'll have our plan for the rest of the day. All right?
Previous motions and objections are laid throughout this case. I will remove motions for judgment of acquittal based on the same argument that I did have with the rest of the case.
I'll deny the renewed motion for judgment of acquittal. Ms. Wright?
Well, I would again renew my motion, based upon the ground previously mentioned, and I would also add, now that Ms. Clark has testified to a state of innocent person against Mr. Bradford, we simply have the motive of someone who would do this other than my client, but the person saying that he took care of it, and did it on deepest significance.
deny them. I need a motion for judgment of acquittal as to Mr. Richardson as well. Rebuttal case, state, yes, and how long do you anticipate needing?
I don't intend, I need to speak with Mr. Bradford in light of her testimony. I believe she admitted the things that I would have basically put on through the detectives. So I don't think that there's a need to recall the detectives. Maybe Mr. Bradford, but I can't, I haven't had a chance to talk to Mr. Hutton about it, on whether we're in fact going to do that or not.
If you don't do that, if you don't call Mr. Bradford, is there a rebuttal?
Yes, sir.
How long do y'all need to make that decision? I'm going to send both juries to lunch, or I'm going to send Mr. Richardson's jury home if you're not going to call a rebuttal. So I'd like to,
Can I have just maybe 5 minutes?
yes, let's do that. We're in recess for 5 minutes. Amongst yourselves yet. That time for Mr. Hayes is coming soon, this afternoon. Mr. Richardson's jury tomorrow. But so still continue to abide by that. You've done it so far, and it's been a long trial, so I know that you can continue to do that so that this case can be tried fairly when we're done. So we're going to break for lunch for Mr. Hayes' jury. I'm going to have you go back to the jury room to get your stuff, and then be back here at 2:30, and we'll be going into closing arguments at that point. So if y'all could follow Ms. Graham out to the jury room, we'll see you at 2:30 p.m. All right, Mr. Richardson's jury, you are going to be free to go. We'll finish up the trial for Mr. Richardson's case. Y'all come back at 2:15, not 2:30, and then we'll have our charge conference. It should be pretty smooth at this point, looking at the amount of work we've already done on these instructions. So we'll just hang out just for a second for Mr. Hayes' jury to come back across the courtroom, and then we'll be in recess.